All right, good morning, everybody, and welcome to IGTV. This is Mark Capers, and Mark is here with the InfraGard Insights. Title of today's talk, Mark?
Being prepared for EDiscovery.
All right, take it away, Mark. Thank you very much.
Good morning, Joe. Good morning, everybody. Today on InfraGard Insights, I'm going to talk about being prepared for EDiscovery. As we live in a bit of a litigious society these days, this is something that we all need to cope with. Going right into it, what is EDiscovery? Essentially, that is, you may be familiar with the legal term discovery process. When your organization is subject to civil or possibly criminal activity through the court systems, if you have evidence or artifacts that are required to be presented to the court by the discovery process, there is an EDiscovery process that you need to comply with to provide that. Typically, as an IT practitioner or an IT expert, you will get engaged in this process as the result of what's called a 26F conference, which is part of the Federal Rules of Civil Procedure, and that's the meeting at which all the parties come together and decide on the scope of the discovery, the artifacts that are going to be provided, and where your participation in that conference will happen is you will most likely be one of the subject matter experts that assists in identification of the key data owners and custodians, location of the relevant systems and networks, and if there are applications or emails, whether desktops are in or out, you're going to be helping to articulate the geographic, physical, and identification of those systems, as well as the location of any third-party systems, what your media sanitation process is, as well as your data storage and your transmission, and what the accessibility of the discoverable information is. Part of the other heavy lifting with the EDiscovery is it's not just the collection of emails or application data or document data. You need to also be able to provide metadata, and the package is typically formatted in such a way that it's searchable, it's indexed, and there's a process that the parties have to come together to agree on how that takes place. So the format of the metadata and the delivered package are going to require significant work to develop. Being prepared for this type of activity, like many things in IT security, the first thing you need to do is engage your leadership, engage the main stakeholders, and in this case it's going to be your legal counsel, enterprise risk, and possibly human resources to pre-plan. As the Coast Guard says, semper paratus, the more prepared you are beforehand, the easier this is to deal with when it actually happens. So up front, you want to acknowledge the risk. Leadership must identify and recognize the risks and costs associated with e-discovery. So depending on the type of organization you're at, you can kind of rationalize where you think that'll happen. If you're a manufacturing and if you have potential safety issues, or most manufacturing places have some likelihood of fatality or injury. If you get sued, there's going to be an e-discovery process for that. Likewise, if you do product or have a lot of intellectual property and it's copyrighted or trademark, that could be another area where if you find yourself in litigation, e-discovery is going to come up. In both of those situations, it's not just email, it could be other documents and other application information. So this is where e-discovery kind of gets a little wild and woolly, because you're going to be doing forensic acquisition on several different types of systems, and all of that needs to be combined into a single discovery package to be delivered to the court. So you need to also have an approved policy for e-discovery, understand what the goals are, make sure the leadership understands their responsibilities, understand how your communications process works, especially around preservation of the evidence and then the acquisition. One court case has found that it is not good enough for, if the admin for the legal counsel sends out an email saying, to the employees in question saying, we're under this activity, we need to preserve this evidence, and, in some cases they requested that they forward the emails. Courts now frown upon that. E-discovery has to be done in a forensically sound manner, like any other evidence to be produced in court. So that's not good enough, and you're going to need to make sure that you have a process for communication, for preservation, and then collection of that evidence. Ahead of time, you want to identify and allocate your personnel and resources to do your e-discovery. And part of that is understanding what you can do in-house versus what might require a third party. If you have capability to do forensic acquisition in your organization, you can leverage that to do e-discovery. If you do not, you will probably want to have a third party either on retainer or have that documented so that you can engage them and understand what their turnaround time is for being engaged and getting involved. So part of planning your e-discovery process moving on, the process needs to be forensically sound. So if you have a forensic acquisition process that you use for security incidents, you can leverage that for your e-discovery process. The preservation methods will need to include some type of hashing or non-repudiation. So again, as you're collecting this information, you need to be able to stand up in court and say, we can prove that this is the data that we collected from these systems, and we can prove that we didn't alter it after it had been collected. So again, that requires forensically sound. You're going to be collecting the data, hashing it, and then preserving it into a deliverable package. So the process should also include the requirement to document the execution of that collection. And again, with e-discovery, you might do several different collections for a package. You might have to go after the email system, an SAP system, a document management system, image collection, fax store, etc. And all of those things will have to be collected in a forensically sound manner and then packaged together in an agreed-to format. So you need to be able to preserve the chain of custody and record everything that you're doing with it. The other activities you want to do ahead of time, and again, this goes back to many of the other things we're doing in information security and a lot of the things that I highlight in Insights, is you need to have a good understanding of where your data is, what its classification is, and what systems does it live on, and what networks does it move through. So map your data and its classification to the systems. If you're using cloud services, understand what information is out in the cloud, and if you need to pull it back for e-discovery, understand how to engage that cloud vendor or that third-party vendor and how to do that. Sometimes they'll have services to be able to help you with your e-discovery, and sometimes there's additional costs to that, so make sure that you understand those things. Also, make sure you're testing your backup in your store so that if you have to go back and pull backup tapes as part of the evidence preservation or verification, you're capable of doing that. And after you have your plan up and running and tested, make sure that you review it all with your leadership, your legal, your enterprise risk, and your human resources so that they're all on board should somebody walk in the door with a subpoena or a court order. And that's e-discovery in a nutshell. Back to you, Joe.
Well, that was certainly brief and to the point, Mark. Thanks. We certainly appreciate you coming on and being patient with us this morning as we went through our different issues.
You were not the only